Chapter 2 Rights in the Indian Constitution. Introduction. A constitution is not only about the composition of the various organs of the government and the relations among them. As we studied in the last chapter, the constitution is a document that sets limits on the powers of the government and ensures a democratic system in which all persons enjoy certain rights. In this chapter, we shall study the fundamental rights contained in the Indian Constitution. Part 3 of the Constitution of India lists the fundamental rights and also mention the limits on these rights. In the past 6 decades, the scope of rights has changed and in some respects expanded. After studying this chapter, you would know what are the various fundamental rights listed in the Constitution of India, how these rights are protected, what role the judiciary has played in protecting and interpreting these rights, and what is the difference between the fundamental rights and the directive principles of state policy. The importance of rights. In 1982, during the constitution work of the Asian Games, the government engaged a few contractors. These contractors employed a large number of very poor construction workers from different parts of the country to build the flyovers and stadiums. These workers were kept in poor working conditions and were paid less than the minimum wages decided by the government. A team of social scientists studied their poor condition and petitioned the Supreme Court. They argued that employing a person to work for less than the minimum prescribed wage amounts to beggar or forced labor, which is a violation of the fundamental rights against exploitation. The court accepted this plea and directed the government to ensure that thousands of workers get the prescribed wages for their work. Machal Lalung was 23 when he was arrested. A resident of Chuburi village of Marigaon district of Assam, Machal was charged of causing grievous injuries. He was found mentally too unstable to stand trial and was sent as under trial to Lokpriya Gopinath Bordoloi Mental Hospital in Tezpur for treatment. Machal was treated successfully and doctors wrote twice to jail authorities in 1967 and 96 that he was fit to stand trial. But no one paid any attention. Machal Lalung remained in judicial custody. Machal Lalung was released in July 2005. He was 77 then. He spent 50 years under custody during which his case never came up for hearing. He was freed when a team appointed by the National Human Rights Commission intervened after an inspection of under trials in the state. Machal's entire life was wasted because a proper trial against him never took place. Our Constitution gives every citizen the right to life and liberty. This means that every citizen must also have the right to fair and speedy trial. Machal's case shows that what happens when rights granted by the Constitution are not available in practice. In the case of the first instance, also there was violation of rights provided in the Constitution, but it was challenged in the court. As a result, workers could get what was due to them in the form of their rightful wages. The constitutional guarantee of the right against exploitation ensured justice to these workers. Bill of Rights. Both these examples show the importance of having rights and of the actual implementation of these rights. A democracy must ensure that individuals have certain rights and that the government will always recognize these rights. Therefore, it is often a practice in most democratic countries to list the rights of the citizens in the Constitution itself. Such a list of rights mentioned and protected by the Constitution is called the Bill of Rights. A Bill of Rights prohibits government from thus acting against the rights of the individuals and ensures a remedy in case there is violation of these rights. From whom does a Constitution protect the rights of the individual? The rights of a person may be threatened by another person or private organization. In such a situation, the individual would need the protection of the government. So it is necessary that the government is bound to protect the rights of the individual. On the other hand, the organs of the government, that is, the legislature, executive, and bureaucracy, or even the judiciary, in the course of their functioning, may violate the rights of the person. Fundamental rights in the Indian Constitution. During our freedom struggle, the leaders of the freedom movement had realized the importance of rights and demanded that British rulers should respect rights of the people. The Motilal Nehru Committee had demanded a Bill of Rights as far as in 1928. It was therefore natural that when India became independent and the constitution was being prepared, there was no two opinions in the inclusion and the protection of rights in the constitution. The constitution listed the rights that would be specifically protected and called them fundamental rights. The word fundamental suggests that these rights are so important that the constitution has separately listed them and made special provisions for their protection. The fundamental rights are so important that the Constitution itself ensures that they are not violated by the government. Fundamental rights are different from other rights available to us. While ordinary legal rights are protected and enforced by ordinary law, fundamental rights are protected and guaranteed by the Constitution of the country. Ordinary rights may be changed by the legislature by ordinary process of lawmaking, but a fundamental right may only be changed by amending the Constitution itself. Besides this, no organ of the government can act in a manner that violates them. As we shall study below in this chapter, judiciary has the powers and responsibility to protect the fundamental rights from violations by actions of the government. Executive as well as legislative actions can be declared illegal by the judiciary if these violate the fundamental rights or restrict them in an unreasonable manner. However, fundamental rights are not absolute or unlimited rights. Government can put reasonable restrictions on the exercise of our fundamental rights. Right to equality. Consider the following two situations. These are imaginary situations, but similar things do happen and can happen. Do you think they involve violation of fundamental rights? Swadesh Kumar is visiting his village. He is accompanied by one of his friends. They decided to have a cup of tea at the village roadside hotel. The shopkeeper knew Swadesh Kumar but asked the name of his friend to know his caste. After this, the shopkeeper served tea to Swadesh Kumar in a nice mug, while his friend was given tea in an earthen cup because he was a Dalit. An order is served to 4 newsreaders of a television channel that they would no longer read the news on screen. They are all women. The reason given is that they are above the age of 45. 2 male newsreaders above the same age are not barred from presenting the news. These are examples of clear discrimination. In one instance, the discrimination is based on caste, and in another, it is based on gender. Do you think that such discrimination is justified? Right to equality tries to do away with such and other discriminations. It provides for equal access to public places like shops, hotels, places of entertainment, wells, bathing ghats, and places of worship. These cannot be any discrimination in this case on the grounds only of religion, race, caste, sex, or place of birth. It also prohibits any discrimination in public employment on any of the above mentioned bases. This right is very important because our society did not practice equal access in the past. The practice of untouchability is one of the crudest manifestations of inequality. This has been abolished under the right to equality. The same right also provides that the state shall confer no title on a person except those who excel themselves in military or academic field. Thus, right to equality strives to make India a true democracy by ensuring a sense of equality of dignity and status among all its citizens. Have you read the preamble of our Constitution? How does it describe equality? You will find that the preamble mentions two things about equality. Article 16(4). Nothing in this article shall prevent the state from making any provision for the reservation of appointments or posts in favor of any backward class of citizens, which, in the opinion of the state, is not adequately represented in the services under the state. Equality of opportunity means that all sections of the society enjoy equal opportunities. But in a society where there are various kinds of social inequalities, what does equal opportunity means? The Constitution clarifies that the government can implement special schemes and measures for improving the conditions of certain sections of society, children, women, and the socially and educationally backward classes. You may have heard about reservations in jobs and in admissions. You would have wondered why there are reservations if we follow the principle of equality. In fact, Article 16(4) of the Constitution explicitly clarifies that a policy like reservation will not be seen as a violation of right to equality. If you see the spirit of the Constitution, this is required for the fulfillment of the right of equality of opportunity. Right to freedom. Equality and freedom of liberty are the two rights that are most essential in a democracy. It is not possible to think of one without thinking of the other. Liberty means freedom of thought, expression, and action. However, it does not mean freedom to do anything that one desires or likes. If that were be permitted, then a large number of people will not be able to enjoy their freedom. Therefore, freedoms are defined in such a manner that every person will enjoy her freedom without threatening freedom of others and without endangering the law and order situation. Right to life and personal liberty. The foremost right among rights to freedom is the right to life and personal liberty. No citizen can be denied his or her life except by procedure as laid down under the law. Similarly, no one can be denied his or her personal liberty. That means no one can be arrested without being told the grounds for such an arrest. If arrested, the person has the right to defend himself by a lawyer of his choice. Also, it is mandatory for the police to take that person to the nearest magistrate within 24 hours. The magistrate who is not part of the police will decide whether the arrest is justified or not. This right is not just confined to a guarantee against taking away of an individual's life, but has wider application. Various judgments of Supreme Court have expanded the scope of this right. The Supreme Court has ruled that this right also includes to live with human dignity. Free from exploitation, the court has held that right to shelter and livelihood is also included in the right to life because no person can live without the means of living, that is, the means of livelihood. Preventive detention. Ordinarily, a person would be arrested after he or she has reportedly committed some offense. However, there are exceptions to this. Sometimes a person can be arrested simply out of an apprehension that he or she is likely to engage in unlawful activity and imprisonment for some time without following the above-mentioned procedure. This is known as preventive detention. It means that if the government feels that a person can be a threat to law and order or to the peace and security of the nation, it can detain or arrest that person. This preventive detention can only extend it only for 3 months. After 3 months, such a case is brought before an advisory board for overview. On the face of it, preventive detention looks like an effective rule in the hands of the government to deal with antisocial elements or subversives. But this provision has often been misused by the government. Many people think that there must be greater safeguards in this law so that it may not be misused against people for reasons other than which are usually justified. In fact, there is a clear tension between right to life and personal liberty and the provision for preventive detention. Other freedoms. You can see that under the right to freedom, there are some other rights as well. These rights, however, are not absolute. Each of these is subject to restrictions imposed by the government. For example, right to freedom of speech and expression is subject to restrictions such as public order, peace and morality, etc. Freedom to assemble too is to be exercised peacefully and without arms. The government may impose restriction in certain areas declaring the assembly of 5 or more persons as unlawful. Such persons can be easily misused by the administration. The genuine protest against an act of policy of government by the people may be denied admission. However, if the people are aware and vigilant in regard to their rights and choose to protect against such acts of administration, such misuse becomes rare. In the Constituent Assembly itself, some members had expressed their dissatisfaction about restriction on rights. Right of accused. Our Constitution ensures that persons accused of various offences would also get sufficient protection. We often tend to believe that anyone who is charged with some offence is guilty. However, no one is guilty unless the court has found the person guilty of an offence. It is also necessary that a person accused of any crime should get adequate opportunity to defend herself or himself. To ensure a fair trial in courts, the Constitution has provided 3 rights. The first right: no person would be punished for the same offence more than once. Second, no law shall declare any action as illegal from a backdate. And third, no person shall be asked to give evidence against himself or herself. Right against exploitation. In our country, there are millions of people who are underprivileged and deprived. They may be subjected to exploitation by their fellow human beings. One such form of exploitation in our country has been beggar or forced labor without payment. Another closely related form of exploitation is buying and selling of human beings and using them as slaves. Both of these are prohibited under the Constitution. Forced labor was imposed by landlords, moneylenders, and other wealthy persons in the past. Some form of bonded labor still continues in the country, especially in brick kiln work. It has now been declared a crime and it is punishable. The Constitution also forbids employment of children below the age of 14 in dangerous jobs like factories and mines, with child labor being made illegal and right to education becoming a fundamental right for children. This right against exploitation has become more meaningful. Right to freedom of religion. According to our Constitution, everyone enjoys the right to follow the religion of his or her choice. This freedom is considered as a hallmark of democracy. Historically, there were rulers and emperors in different parts of the world who did not allow residents of their countries to enjoy the rights to freedom of religion. Persons following a religion different from that of the ruler were either persecuted or forced to convert to the official religion of the rulers. Therefore, democracy has always incorporated the freedom to follow the religion of one's choice as one of its basic principles. Freedom of faith and worship. In India, everyone is free to choose a religion and practice that religion. Freedom of religion also includes the freedom of conscience. This means that a person may choose any religion or may choose not to follow any religion. Freedom of religion includes the freedom to profess, follow, and propagate any religion. Freedom of religion is subject to certain limitations. The government can impose restrictions on the practice of freedom of religion in order to protect public order, morality, and health. This means that the freedom of religion is not an unlimited right. The government can interfere in religious matters for rooting out certain social evils. For example, in the past, the government has taken steps banning practices like sati, bigamy, or human sacrifice. Such restrictions cannot be opposed in the name of interference in the right to freedom of religion. The freedom on the right of to freedom of religion, the limitations on the right to freedom of religion always produce tensions between followers of various religions and the government. When the government seeks to restrict some activities of any religious group, people of that religion feel that this is interference in their religion. Freedom of religion becomes a matter of political controversy for yet another reason. The Constitution has guaranteed the right to propagate one's religion. This includes persuading people to convert from one religion to another. However, some people resent conversions on the ground that these are based on intimidation or inducement. The Constitution does not allow forcible conversions. It only gives us the right to spread information about our religion and thus attract others to it. Equality of all religions. Being a country which is home to several religions, it is necessary that the government must extend equal treatment to different religions. Negatively, it means that the government will not favor any particular religion. India does not have any official religion. We don't have to belong to any particular religion in order to be prime minister or president or judge or any other public official. We have also seen that under the right to equality, there is a guarantee that government will not discriminate on the basis of religion in giving employment. The constitution run by the state will not preach any religion to give religious education, nor will they favor persons of any religion. The objective of these provisions is to sustain and nurture the principle of secularism. Cultural and educational rights. When we talk of the Indian Constitution or the Indian society, the image of diversity comes before our minds. India is not made up of monolithic society. We are a society that has vast diversity. In such a society that is full of diversity, there would be social sections which are small in numbers compared to some other groups. If a group is in minority, will it have to adopt the culture of the majority? Our Constitution believes that diversity is our strength. Therefore, one of the fundamental rights is the right of the minorities to maintain our culture. The minority status is not dependent only on religion. Linguistic and cultural minorities are also included in this provision. Minorities are groups that have common language or religion and in a particular part of the country or in the country as a whole, they are outnumbered by some other social section. Such communities have a culture, language, and a script of their own, and have the right to conserve and develop these. All minorities, religious or linguistic, can set up their own educational systems. By doing so, they can preserve and develop their own culture. The government will not, while granting aid to educational institutions, discriminate any educational institution on the basis that it is under the management of minority community. Right to constitutional remedies. One would agree that our constitution remains a very impressive list of fundamental rights, but merely writing down a list of rights is not enough. There has to be a way through which they could be realized in practice and defended against any attack on these rights. Right to constitutional remedies is the means through which this is to be achieved. Dr. Ambedkar considered the right to constitutional remedies as heart and soul of the Constitution. It is so because this right gives citizens the right to approach a high court or the Supreme Court to get any of the fundamental rights restored in case of their violation. The Supreme Court and the High Courts can issue orders and give directives to the government or the enforcement of rights. The courts can issue various special orders known as writs. Number 1. Habeas corpus. A writ of habeas corpus means that the court orders that the arrested person should be presented before it. It can also order to set free an arrested person if the manner or grounds of arrest are not lawful or satisfactory. Number 2. Mandamus. This writ is issued when the court finds that a particular office holder is not doing legal duty and thereby is infringing on the right of an individual. Number 3. Prohibition. This writ is issued by the higher court, high court, or the Supreme Court when a lower court has considered a case going beyond its jurisdiction. Number 4. Quo warranto. If the court finds that a person is holding office but it is not entitled to hold that office, it issues the writ of quo warranto and restricts that persons from acting as an office holder. Number 5. Certi orari. Under this writ, the court orders a lower court or another authority to transfer a matter pending before it to a higher authority or court. Apart from the judiciary, many other mechanisms have been created in later years for the protection of rights. You may have heard about the National Commission of Minorities, the National Commission on Women, the National Commission on Scheduled Caste, etc. These institutions protect the rights of women, minorities, and Dalits. Besides, the National Human Rights Commission has also been declared and established by law to protect the fundamental and other kinds of rights. Directive principle of state policy. The makers of our constitution knew that independent India was going to face many challenges. Foremost among these was the challenge to bring about equality and well-being to all citizens. These also thought that certain policy direction was required for handling these problems. At the same time, the Constitution did not want future governments to be bound by certain policy decisions. Therefore, some guidelines were incorporated in the Constitution, but they were not made legally enforceable. This means that if a government did not implement a particular guideline, we cannot go to the court asking the court to instruct the government to implement that policy. Thus, these guidelines are non-justifiable, that is, parts of the Constitution that cannot be enforced by the judiciary. Those who framed our Constitution thought that moral force behind these guidelines would ensure the government would take them seriously. Besides, they expected that the people would also hold a separate list of policy guidelines. Besides, they expected that people would also hold the governments responsible for implementing these directives, so a separate list of policy guidelines is included in the Constitution. The list of these guidelines is called the Directive Principles of State Policy. What do the Directive Principles contain? The chapter on Directive Principle lists mainly three things. Number 1. The goals and objectives that we as a society should adopt. Number 2. Certain rights that individuals should enjoy apart from the fundamental rights. Number 3. Certain policies that the government should adopt. You may get some idea of the vision of makers of our Constitution by looking at some of the directive principles shown below. The governments from time to time tried to give effect to some directive principles of state policy. They passed several zamindari abolition bills, nationalized banks, enacted numerous factory laws, fixed minimum wages, cottage and small industries were promoted, and provisions for reservations for the uplift of the scheduled castes and scheduled tribes were made. Such efforts to give effect to the directive principles include the right to education, formation of Panchayati Raj institutions all over the country, with a partial right to work on the Employment Guarantee Program and the Midday Meal Scheme, etc. Relationship between fundamental rights and directive principles. It is possible to see both fundamental rights and directive principles as complementary to each other. Fundamental rights restrain the government from doing certain rights, while directive principles exhort the government to do certain things. Fundamental rights mainly protect the right of individuals, while directive principles ensure the well-being of the entire society. However, at times when government intends to implement directive principles of state policy, it can come in conflict with the fundamental rights of the citizen. This problem arose when the government sought to pass laws to ground that they would violated right to property. However, keeping in mind the societal needs that are greater than the individual interests, the government amended the constitution to give effect to the directive principles of state policy. This led to a long legal battle. The executive and the judiciary took different positions. The government claimed that rights can be abridged for giving effect to directive principles. This argument assumed that rights were a hindrance to welfare of the people. On the other hand, the court held the review that fundamental rights were so important and sacred that they cannot be limited even for purposes of implementing directive principles. This generated another complicated debate. This related to the amendment of the Constitution. The government was saying that the Parliament can amend any part of the Constitution. The court was saying that the Parliament cannot make any amendment that violated fundamental rights. This controversy was settled by an important decision of the Supreme Court in Kesavananda Bharati case. In this case, the court said that there are certain basic features of the Constitution and these cannot be changed by Parliament. We shall discuss this in greater detail in Chapter 9 on Constitution as a living document. Conclusion. In the writings of Jyotirao Phule, born in 1827, died on 1890, a radical social reformer from Maharashtra, we find one of the earliest expressions of the view that rights include both freedom and equality. During the national movement, this idea of rights was further sharpened and expanded to constitutional rights. Our constitution reflected this long tradition and listed the fundamental rights. Since 1950, the judiciary has functioned as an important protector of rights. Judicial interpretations have expanded the scope of rights in many respects. The government and administration of our country within this overall framework, rights enforce limitations on the functioning of the government and ensure democratic governance of the country.